Okay, good morning. This is Luca Escoffier speaking from Tokyo, the EU-Japan Center for Industrial Cooperation. Today we are being hit by a typhoon, so the connection is not that good. Hopefully it will be for the next 40-50 minutes. And we're starting today the webinar of the Technology Transfer Series, number 30. On EU-Japan adequacy decision, a data protection officer's journey between data flow and authorities. As usual, before introducing our guest speaker today, I would like to spend a couple of words about the help desk. Here on this first slide, you see my contact details if you want to be in touch. The website of the help desk if you want to see other resources that we have available. A survey that you may be interested in participating in that we are continuously running on our website. And of course, if you want to register and always be updated with the latest, you can be a member of our mailing list. Without further ado, I would like to introduce our guest for today, my personal friend, Daniel Schwartz. Daniel is the CEO and founder of ITT GBS Tokyo, with an expertise in artificial intelligence, data ethics, computer science, and is a certified data protection officer by the European Center on Privacy and Cybersecurity. With over 15 years of IT experience as a developer, architect, and security specialist in international environments, his ambition lies in supporting a new generation of legal tech experts. Currently, Daniel is contributing at the IEEE in the field of ethics and emulated empathy in autonomous and intelligent systems. And he will explain what this means. The rest of his free time, that I know is very little because he's very busy, he's supporting startups, students, and also organizations with privacy questions from Japan and Europe. And I would also add to these that Daniel and I have been working for the past probably 6 months together on the privacy support program, which is one of the pro bono services that we offer through the help desk. If you're interested, you can take a look at the website or just send me an email. Daniel, welcome. Despite the typhoon, the floor is yours.
Thank you very much, Luca, for this very kind introduction. About emulated empathy, it's actually about the simulation of emotions in an artificial intelligence environment. So it's a very interesting topic. Unfortunately, I'm not allowed to disclose more, but maybe next year then that it's going to be more public, and I hope I can also talk more about this topic in the future. As we are a very little group today. Anyway, thank you very much for joining today. I know it's still quite a difficult topic, especially what to understand under a data protection officer's journey. And I hope that at least at the end of the webinar, you can maybe share some pain we have in our role. In order to go through today's webinar, I would also kindly ask you to wait with your questions until the end of the session. Of course, only if you have any. Otherwise, today's session is intended to give you inspiration and some key points to consider, whether you are in the middle of a compliance transformation or you are in the middle of planning to send data from Europe to Japan or vice versa. That said, just the first slide is the legal disclaimer. Just one more time, I have to mention that this is not a legal advice today. It's not a consultation. It's just pure for educational purpose only. With this said, let's have a look on today's menu, where we have a look on the European-Japan adequacy decision in terms of cross-border data transfer, and on the role of a data protection officer, including a little side adventure into the latest AI ethics guidelines by the European high-level expert group. in order to start, so the adequacy decision was implemented this year on January 23rd between Europe and Japan in addition to the European-Japan Trading Agreement. This agreement sets a new milestone in the development of free data flow between our nations. In order to achieve this agreement, Japan added supplementary rules applicable to data transfers from Europe to Japan. And of course, this came, so as a little background information, this came very much in handy since both legislations pointed out various conditions to allow cross-border transfers in general. Since the Japan's legislation Act on the Protection of Personal Information, short APPI, has requirements for consent, so consent for various activities, it was a hardship to demonstrate that received consent, especially related to employees, were very hard to show that this consent was freely given, or even situations occurred where consent couldn't even be given or were just simply not given. On the other side, as the GDPR offers other mechanisms which are defined under Article 46, it was also needed to consider. So for example, if you were thinking about binding corporate rules or model clauses, that those were high cost and labor expensive. And therefore, the adequacy decision does many things easier. As mentioned, overseas transfer, according to Article 24 of the APPI, is bound to restrictions in terms of obtaining prior consent from a data subject. However, with the exception that if a foreign country is specified and recognized by the Privacy Commission, the short PPC, having a level of equivalent protection to that of Japan, consent would not be required. Anyhow, it should be mentioned that consent is also the legal basis to process personal data under the APPI, as well as under Article 23 of the APPI, the obligation to obtain consent if personal data will be shared with third parties. So there are also exceptions, but for today I will not go into detail. So anyway, from the high-level perspective, this can be very tricky because overseas transfer, data processing, and sharing are different key principles, and this, of course, also applies to the GDPR. The differences is we have more options in the GDPR to choose from, and actually, from a DPO perspective, I'm thankful for that because consent can be very difficult to handle. As for the GDPR, the usage of safeguards, again mentioned and defined under Article 46, like model clauses, binding corporate rules, consent, etc., are not required anymore. However, the controller needs to ensure, so controller in terms of the entity who is responsible, needs to ensure that affected data subjects are informed about this transfer, and that such information are reflected in the policy. So in terms of accountability, the controller needs to make sure that the data subject is informed and that the data subject has the possibility to find this reflection in the policy and that he has easy access to it. Furthermore, it should be considered that the adequacy decision could be revoked any time. Well, we could discuss about the probability, but it should be in the interest of all involved parties in such a constellation to have a backup plan in place, as it could affect the overall compliance. Okay, and here, okay, this is the problem, what you said. Okay, so some things don't show up correctly. Anyway, I just gave you here an overview about the, let's say, supplementary rules or the guarantees we have from the European perspective for European data subjects. So those guarantees are, for example, that data is not further transferred abroad. So this means if we are now sending data from Europe to Japan, that there might be, and this was also an opinion from the European Data Protection Board, that can happen that data would be sent from Japan to another country. So this is something the adequacy decision wants to avoid. Of course, there are possibilities under safeguards, necessary safeguards by the GDPR and the APPI that you can do that. But as a general guarantee, the adequacy decision is ensuring that data is not further transferred abroad. So of course, unless consent has been given, for example, or has been obtained. Data is processed down to purpose necessity. Data is also processed down to the purpose of transfer. This is what I mentioned before, that those are different things. Data is kept for no longer than necessary. So then we're talking again about retention times, for example. Data is kept accurate and up to date in terms of integrity. Data processing with appropriate security measures would be found under Article 25, for example, privacy and protection by design, and additional safeguards for sensitive data, which is also very an interesting and important point because we have differences in our legislations. So for example, in Japan, if you have consent from a data subject, you can process sensitive data. By the GDPR, it's in general prohibited unless you have consent, but even it depends on the member state law, for example, they can provide the provision to say, dear data subject, even you give consent, this controller is not allowed to process this kind of data. Wow, now there's an animation inside. Okay. Including what I've said before about the data subject itself, we also have, in addition, in terms of data subject rights, we now have the guarantee that European data subject rights are also in place and guaranteed. So we're talking about information about the purpose of processing. We are talking, wait a second, no, it's lagging here, but sorry about that. Okay, so about the information about purpose of the processing under Article 15, for example, request of correction or deletion would be Article 16, 17, and the request of access under Article 13, which is also one of the most important data subject rights we have. And also the adequacy decision points out the possibilities for a data subject to obtain redress in terms of sending a letter of complaint to the Japanese Personal Information Protection Commission, the PPC. Data subject will receive support in terms of file civil actions to obtain damages or injunctions and have access to recourse to extensive mediation. What a bit, and this is something we can discuss about because they're stating we can benefit from equivalent rights. So equivalent rights is not 100%. Let's talk about this topic a bit more because this is still something where our main discussions are about. And this is a little point out here of some differences we have in our legislation and which are not part of the supplementary rules, for example. So this is the other side of the medal, which does open many questions related to differences between the APPI and the GDPR. Some are, like in this example now, to the point of my current knowledge, not part of the supplementary rules, as I said. And just, for example, like the data breach notification, according to the APPI, there's no or there is an obligation to report, while we have no obligation to report this data breach in a certain amount of time. While the GDPR clearly says you have to report within 72 hours if it's feasible or if there's a risk for data subjects present. We also have no full obligation in terms of filing and maintaining records of processing. So this is also something special within the APPI from my point of view, that you only need to provide these records of processing when you share personal data with third parties. In terms of GDPR, we are fully maintaining records of processing. Another thing what is or belongs to the data subject rights is the term data portability. According to the Japanese law, we have to, or we are obliged to offer a data subject a copy of the data we obtained. The GDPR is a bit more specific about this, also that we have to provide the information in a structured and machine-readable format. Okay, so no, oh no, this shouldn't happen. Okay, let's do a bit. All right. So in addition to the example now, we also have to bear in mind that we have still the territorial scope under Article 3 of the GDPR and its obligation. And also this obligation is not overruled by the adequacy decision. So this means that the GDPR still applies to controller or processor not established in the Union, processing personal data of data subjects once you offer goods or services to data subjects or monitor their behavior within the European Union. The same goes with the latest adjustment of the APPI as stated in Article 75. I also mentioned this earlier on the slides, that we have a territorial scope now. This makes it even a bit more complicated, and from my point of view, we currently have here a gap also in the term of equivalent rights. It's debatable. Nevertheless, we have at least now a framework to send personal data from Europe to Japan and vice versa, so something we can use to justify our framework. What I do recommend when planning, why I have now this here, I don't know, okay. So what I do recommend when planning cross-border transfer is to identify each rule in the architecture. And this is indeed a very complex task and requires a lot of effort to understand all the processing activities and all the responsibilities. And what is also a bit difficult is that the APPI itself does not differ between controller or processor. All parties are data handler. So the situation changes once you entrust personal data to another data handler. So you could compare this then in this moment as to a processor. And also this entrustment needs to be verified through a contractual agreement. So in any way, a structured map can be very helpful, including also the data flow as well as the responsibilities and the activities to determine appropriate safeguards and other possible obligations. In addition, what also came up very often in the past, because only in the GDPR, you will find only Article 26 and 28 in terms of joint controller and processor. And in the past, we also had many situations where we came up to controller relationships. And there were pretty much a lot of debates going on, saying that controller was not what we call was not possible because there was no defined article about this relation. It was very interesting because even from the European Union there are more clauses and contract clauses offering controller to controller contract. It is a bit tricky if you're not in this kind of field because it's more by the context, and when you are coming into controller to controller relationship, it will be more related to a data share agreement where all, again, of course, the responsibilities, the GDPR principles, etc., are pointed down. So even there is no own article about controller to controller relationship, it is there and it is possible in a compliant way. So once we understand the legal implications, we also need to look on our technical requirements. So as the data is flowing through in our paper, we also have to face physical limitations. So here in the picture you see a website request I did from Japan to the European Data Protection Board website, and I was just following the traffic from Japan to Europe, and as you can see, it went through the States, it went through Norway, through UK, until the end I was in Brussels. So in general, we are obliged to the Article 25 of the GDPR. It means of having security measures in place. Of course, you could debate about this, as every email also would be then a data breach per se. But for this moment, where we can proactively propose and implement security measurements, for example, encryptions, we minimize risks. And this is very good for your accountability. So my recommendation in this case is that you have to identify and categorize your risks. For example, where's my data flowing? What kind of data in transit is going to what country, for example? I have to identify and categorize my data, and I do have to propose security measurements in terms of encryption, for example. So when we are traveling around the world, sooner or later we may be going to end up in our office. And this is, of course, where we also still have to think about where our data is going. Everything is, of course, also under the Article 25. And this also means that we have to identify and categorize our risks, our data. We have to propose security measurements. What it also works very well in terms of security measurements, or to have a framework to demonstrate compliance together, demonstrate compliance in terms of GDPR with international standards. I could, for example, recommend the ISO standard. And in addition to that, once we have our architecture in terms of data flow, we also have to keep and bear in mind that we should never underestimate the creativity of our customers and employees. So this means when we build solutions or when our employees are working with our IT, that it can happen sometimes that we are facing shadow IT situations, or that even employees start to use software which is not part of your corporate software stack to exchange data, and your IT admin will have a very hard time to remain in control of this situation. What I would recommend as well is to check out the homepage of the European Union Agency for Cybersecurity, short ENISA. You will find there a lot of information about latest security guidelines and also other inspirations. So with this said, I have here a little checklist, at least what we have talked so far. So important is that you define the rules and the flow in your data transfer architecture. It is important that you verify necessary contracts and safeguards, that you have appropriate end-to-end security measures in place, that data subjects can enforce their rights, that of course you need to monitor your implementation, your compliance implementation, because at the end you will never be fully compliant. So that's why you have to keep on going. Demonstrate your compliance. Demonstrating compliance also means that not only to demonstrate to authorities, but also to make it accessible to individuals. Include all information into your records of processing. So I mean, like really everything in terms of like what contracts are in place, from where the data is going, where is it flowing, what security measurements are in place, and et cetera, et cetera, et cetera. And also have a review on local guidelines, so released by DPAs, because this is something where you end up pretty soon, especially when you are fighting with international data transfer, that sooner or later you're not only facing one data protection authority, you are going to face multiple data protection authorities based on where the processors or joint controllers are, et cetera, et cetera. So then it's getting very interesting and very time-consuming. So with this said, yes, who would be the best person to do this? Of course, your data protection officer would be the right person. The data protection officer is in his primary role to ensure that data processing is compliant to applicable laws, so of course, according to the GDPR, which is defined under Regulation 2018-1725, which is now released last year for institutions and bodies, which is a copy of the Regulation 2016-679 with some adjustments. And the question is now when to appoint a DPO. So this is a question I get very often, and I can only say it depends. I mean, it really depends. The point is the GDPR has so much room for interpretation when you need to appoint a DPO. So what I've learned in the past is maybe not to stick too much to the GDPR, maybe go to a data protection authority and look what, or if do they have some sort of guidance. And in the past couple of months, yes, they were happening, or there was happening a lot. So in terms, for example, like the ICO, the British DPA, or the French CNIL, and they were distributing guidelines en masse. And the ICO, for example, says it depends on the core activities of your company. So like, okay, there is the general obligation, public authorities, they do need a DPO, no doubt about it. But about an organization, well, it depends. Okay, so the ICO stated the core activities are important. So are you processing on a large scale? Do you do it regular or in a systematic monitoring, et cetera, et cetera, et cetera? But the baseline is, the question is, your company does money with what? And when your company is processing a lot of personal data because of services and so on, then you know, okay, the company is generating revenue by having services, selling to customers, and that's why generating revenue and processes personal data. In Germany, and this is now the other story, when you're fighting with authorities in Germany, you have the special thing, for example, that in Germany, the obligation to appoint a DPO is also connected to the members, to the number of employees you have. So a couple of months ago, it was like 10 people. If you have 10 employees, you will need to require a DPO. Then it was changed a couple of months ago again, that you now need a DPO when you have at least 20 employees. And last couple of weeks, I also heard some rumors that they are going to change this again. Once you have 50 employees, you will need to appoint a DPO. So it's still a bit difficult. Nevertheless, what you can do in a proactive manner, you can always appoint a DPO. Just in comparison to the APPI, there is currently no obligation in Japan to appoint a DPO. With this said, in the APPI Article 20, in Article 20, there are obligations you have to put in place in terms of that you have measurements to prevent data breaches, ensure security measures, data integrity, policies, and education for your employees. And therefore, if you appoint a person in charge of handling this or of handling personal data in these topics, it would be an example for necessary and proper measurements. So this would be a good standing for a company if you have such person in your team. The tasks for a DPO are defined under Article 39. So of course the role is to inform and advise, to monitor the compliance, advise in terms when you have to write a data protection impact assessment. The DPO is also obliged to cooperate with supervisor authorities, is the contact point for supervisor authorities, does the risk management, maintains a register of processing activities, and supports data subjects to enforce their rights. With this said, in the position according to Article 38, the DPO is involved in all issues related to protecting personal data, is independent regarding in the exercise of his tasks. Another safeguard also to build the trust between the company and the DPO is that the DPO is bound to secrecy and confidentiality and only reports to the highest management. With this said, those are the basics of the GDPR about a data protection officer. In general, a DPO is a very challenging position because you require a lot of expertise in multiple domains. So it's not only that you have to know about applicable laws, so not only the GDPR, but also other national laws. We also have the problem in the European Union that we have the GDPR, yes, fine, but also every member state has their own adoption of the GDPR. So this means we have also specialties in each member state. And even when I go back to Germany, we also have the states in Germany with their own data protection authorities and also their own adjustments. So you really have to dig deep once you, you really have to dig deep to really get everything together. So in order to get the big picture, you require knowledge about information technology, or short IT. You need project management skills. You need at least some knowledge about security, auditing, and communication. Of course, in bigger environments, in enterprise environments, you would have a data protection office consisting of multiple data protection officers, lawyers, IT experts, and so on. Because obviously not one person can not know everything in such a detail. Anyway, DPO is a contact communication bridge for the organization. The DPO needs to talk to the marketing, needs to talk to IT, R&D, to finance, to the law department, to quality assurance, to HR, to the management, and also to the defined tasks by the GDPR. You are contact point for the data subjects. You are contact point for possible stakeholders, other organizations, and authorities. So this is really a full-time job. What makes this rule so interesting? That, of course, it depends on the company and what you're doing, but what I want to point out is what happens when you combine all this knowledge in terms of legal tech, and now you have this innovative job role, and you come along with very innovative technology. And this is a benefit for every company who is, for example, now in the field of AI or blockchain or whatsoever. Because in general, as a developer, you are forced to deliver. There's, in general, no time for security or other things you have to think about. And that's why a DPO is really helpful, for example, in terms of R&D. And depending on your specializations, or my terms, for example, I have my specialization also in ethics, it's getting really interesting. So even, for example, now when we have a look at the human data model, this is something I'm working on right now. So this is also just from my education and awareness program, just to understand for a developer, okay, what data are we collecting? Is it personal data? Is it sensitive data? What happens if I bring my data into the database to feed my AI, for example? So what kind of bias do I have? Are there any cultural differences? Are there ethical points to consider about? And what is our current point of knowledge, what we have about this data? And we bring this together, all this information into one box. And again, we have to think about, okay, where does this data come from? When did we collect it? How did we collect it? And of course, why did we collect it? So there are a bunch of questions you have to consider when you are developing AI and when you start to train and to test your AI, your machine. So as a little side adventure, as I mentioned, the latest European framework for trustworthy AI by the high-level expert group. This is something I wanted also to share with you. If you are in the field of AI, I compressed the whole guideline in just a few slides, so you're free to use it. There's no problem. Just let me, okay, now it's saying, okay. All right. So in terms of AI and trustworthy AI, there were 3 components pointing out so that AI needs to be robust, lawful, and ethical. And when you have a look at the basic structure of trustworthy AI, where we think or where we are looking at 4 ethical principles, the implementation of 7 key requirements, and when you look on the right side, the applicable laws, which the framework is actually also based on. The framework itself does not go into the applicable law, so it's really just focused on ethics and the robustness. Okay. All right, so what I want to point out is that there is a part in this guideline where the teams need to come together. We have a process or 2 processes called the non-technical method and the technical method. So there's one evaluation from the technical perspective where you have to talk with your R&D, where you have to go through your design, you have to go through the code, etc. You have to look on your supply chain, the end-to-end process from where you collect your data, what's the bias, where does the data go to, how does it work, how is it connected, etc., etc. But also the non-technical methods in terms of that you are sitting together with all stakeholders and also thinking about policy procedures, ethical explainability, and things like this. So what's happening in this framework, for example, that you have a process to follow in terms of use, analyze, redesign, develop. And this is also where a DPO has a position, because a DPO can give advice during all those steps and processes, or at least should be able to. according to this guideline, and those are of course recommendations, how to structure your team. So you have the executive management, you have the legal department, you have the development, you have the QA, the HR, the procurement, and the business as usual, so the operations. And guess what? The DPO is somehow connected to all those domains and communication bridge. This is the final assessment list of the guideline, and also for a DPO, then a possibility to support your team in order to develop an ethical, compliant AI solution. I will just not go too much into detail. As I said, you are free to have the slides and use them. It's no problem. Because I have to look at the time here, but sorry. So, for the checklist, yes. A DPO does support and maintain your compliance. A DPO connects the domains and important communication, or is a communication bridge for those domains. A DPO can be appointed without obligation, can fulfill multiple roles, which is very good. Of course, there's one thing to consider. There shouldn't be a conflict of interest. So this is very important. So a conflict of interest, for example, could happen if you are the CEO of a company and you are also your own data protection officer. This wouldn't work. And a DPO can be an internal or external resource. So there are pros and cons about this if you are now going to train one of your employees to a DPO, which of course can also be very time and cost expensive, but you can also hire an external resource as a DPO, which of course can also be expensive depending on your requirements, but has some benefits in terms of that external contractors or external DPOs can also bring fresh new inspiration for certain topics. What's a bit to consider is that there's still no clear guidance about the level of expertise DPO needs to have. So this is still an ongoing issue. The position of a DPO is still underestimated. So in terms of we could just use anyone to be DPO and we have fulfilled our obligation. Even, of course, the GPS says, yes, the person should be knowledgeable, but doesn't explicitly say to what level. And depending on the country, DPO also faces additional risks. So in terms also that he would be liable for fines or even for imprisonment and things like this. So, long story short, what the last information I want to give you for the weekend. So what's hot? Please keep in mind the e-privacy regulation is still ongoing. I include a link as well. So this is the revised proposal for the 4th of October. I just wanted to give you the information because it's probably also going to happen again that there's some sort of panic mode next year when the e-privacy comes into force. So just please keep it in mind. Also for the APPI, the 3 years terms is over, so it's expected that there is going to be a regulatory review on the APPI next year. And this is also something very fresh out of the open. It's the latest press release from the Court of Justice of the European Union related to cookie privacy. So based on the judgment, it is now mandatory that storing cookies requires Internet users' active consent and that pre-ticked checkboxes are therefore insufficient. I also included the source link for you. And on the 17th of October, the Spanish DPA fined a company in Spain with a 30,000 euro fine related to the cookie policy problem. So, yes, I think I did it. I had to cut it a bit down. I'm sorry about that, but I have to say I also still experimenting a bit about the content, and 1 hour is maybe a bit short. Anyway, thank you very much.
Thank you, Daniel. I will leave maybe a minute to the audience, and I would ask maybe a first question to Daniel, while the attendees might have some questions to type in the chat window. So, as far as you know, what is the current situation of enforcement of the GDPR outside of Europe for companies though that are outside of the EU geography, as far as you know?
Oh, as far as I know, yeah, I mean, this is quite a story. I mean, the last thing I followed last year was that the British ICO was enforcing the GDPR on a company from Canada. I didn't follow this now until the end, but there was a Canadian company processing personal data from the UK in terms of advertisements. So this was an analytic company, and they were breaching several articles on the GDPR and also had no representation in Europe. What I heard, at least, of course, that they are going to file a case at the national court, but also depending on the, let's say, situation together with the other country, of course, you have still the option of usage of international law and authority cooperation. So this means, of course, European data protection authorities have some sort of firepower to enforce the GDPR outside the European Union. Even a company doesn't have a physical representation established in Europe. So it is possible. It is possible. At the moment, I didn't hear any enforced fines yet, but technically it's possible, definitely.
I understand. In the meantime, we have a first question from Christoph. I don't know if you can read it from the chat window. Maybe it's easier because there is some problem with the connection.
So the question is regarding the need to record processing in API when data is provided to a third party. Is there any format specified or accepted best practice? Well, the best practice is still, let's say, debatable. What you would do, so at least what I'm doing is I document in general everything. So of course I have to document the legal basis. So in terms of the API, I need to demonstrate that I have obtained the consent, for example, from the person to share the information with this third party. So this also includes the purpose for this transfer. This also includes in terms of retention, what I'm going to do once the purpose is not there anymore with the information. For example, what kind of safeguards I have in place. So in terms like, okay, I'm sending the information to my third party in Europe based on the adequacy decision. Therefore, I do not need consent for this data transfer out of Japan. So this kind of information is something you should consolidate, bring together in your privacy management software, for example, or in a well-structured Excel sheet, or in your personal database you use as a DPO, for example. You're welcome. Okay. So, on the data subject's rights for obtaining redress, like sending a letter to the DPA, file civic action or mediation, is there anything businesses should be doing to make data subjects aware of how to get redress and how this is done in Japan? So this is a very good question, and also this is something what you can use as a company to demonstrate your proactive, let's say, mindset. In general, everyone is redirecting at first to the PPC. So the PPC has, let's say, on their homepage, specifically for this kind of questions or complaints, a phone number, for example, or email address where you can contact directly the PPC and file your complaint, for example. So in general, a data subject has no obligation to a specific format, for example. So because in general, the data subject will go directly to the PPA and not to the company. Well, this said, of course, the data subject would go to the company, would ask, hey, what's going on? And if there's no contact or mediation possible, he would go then to the Data Protection Authority. The Data Protection Authority would then also get back to the company and would knock on their doors and say, like, hey, we have a request from person XYZ. He sent you an email about his complaints. You didn't respond. What's going on? And when also the company wouldn't start to react on that, yes, then it could get quite nasty, because then also the Data Protection Authority would start to dig deeper. So what you can do is, of course, you can support your customers by, of course, writing down in your privacy policy who is your responsible data protection authority in Japan. So, of course, this would be the PPC. You could also then clearly write down on your page, okay, this is the homepage, this is where you need to go, where you get the information. This also would be the phone number of the PPC, where you can call, etc., etc., etc. So this is, yes, something you can do proactively to give the information to your customer, because otherwise the customer doesn't know at first at all. So do the same thing, open up Google or your search engine of your choice and look around. So yes, this is something you could do proactive.